Copyright Office for today's webinar on the recently proposed changes to the Compendium of U.S. Copyright Office practices. My name is Whitney Lewandowski, and I am the Attorney Advisor in the Office of Public Information and Education, also known as PI. PI is here to help the public, applicants, copyright owners, and users understand copyright law and office practices and procedures.
And my name is Eric Burton. I am the Deputy Director of Registration Policy and Practices, which is charged with administering the U.S. copyright registration system. When you submit an application to the Copyright Office, RPP staff examine the application and copies to make sure that all legal and formal requirements of the copyright law are met. The Compendium is the administrative manual for the Copyright Office. It is used by the office's staff in their day-to-day work. It also provides guidance to the public, practitioners, scholars, and the courts regarding the office's practices and related principles of law.
So today we will be discussing the proposed changes to the Compendium, which were released on March 15th. This draft is the first update since September 2017. Our goal for today is to provide insight into the office's proposed changes and respond to any questions you may have. We will leave time for questions and answers at the end. The office has in hand a few commonly asked questions, and you can submit a question during this session by typing your question into the Q&A box on the bottom right hand of your screen. Questions will be reviewed by staff and recommended for response. I will relay your questions to Eric. If we are unable to get to your question during this webinar, we will follow up with you on an individual basis if you include appropriate contact information with your question. So all phones are muted for the duration of the program to reduce background noise. If you lose audio, please call back in. And a recording of this webinar will be made available on the Copyright Office's YouTube channel. Let's begin. Eric, what's the office's process for updating the Compendium?
So the office goes through a multi-step process before the draft becomes final. Proposed amendments are prompted by court decisions, regulatory updates, and practice changes. Draft language is vetted through a committee made up of staff from all across the office. When the proposed policies and practices are reviewed and approved by the register, we produce a draft compendium. The draft is then released for public commenting prior to final review and adoption.
And where do we find this new draft? How do people know what changes we're proposing?
The draft is available on the office's website, and we pulled up here a screenshot of that. The office has provided tools to identify and review the proposed changes. We have a revision history document which provides a list of sections that have been added, deleted, or amended. The office also provided red lines that compare the proposed changes with the current version of the Compendium.
So we have the Compendium that was released in 2017 and this draft. Which version should people use if they need guidance for office policies and practices?
Good question. The current version of the Compendium will remain in effect until the office has reviewed the comments on the latest draft and has released the final version of this update.
Okay, good to know. So what if people have thoughts or suggestions about the proposed changes?
Well, the office welcomes public comments on the draft. Comments may be submitted through regulations.gov until May 14th, 2019. Instructions for submitting comments are available on the draft Compendium webpage. The office only accepts comments, however, through regulations.gov, but if electronic submission is not feasible, please contact the office using the contact information that will be provided at the end of the webinar for special instructions.
Okay, great. So we've got copyright.gov for the proposed changes to the Compendium, and we've got regulations.gov to provide an official comment on these changes. And we have a screen capture here. So on the left, you'll see an example of the instructions for submitting a comment, and on the right, we've got a screen grab of regulations.gov. So that's how your comment will look when you input it and submit it to us. So what are we going to cover today?
Today, we'll be covering 4 main topics. First, updates to Chapter 900, Works of the Visual Arts, in light of the Supreme Court decisions in Star Athletica versus Varsity Brands. Second, practice changes made throughout the Compendium to reduce correspondence and pendency times for copyright claims. Third, we'll be discussing updates made as a result of recent rulemakings. And finally, we'll end the formal part of this webinar with a brief discussion of some new examples that were added to the publication chapter in light of the office's recent study titled The Making Available Right in the United States.
Thanks. So, beginning with Star Athletica, the public draft provides detailed information concerning the office's practices and procedures for examining useful articles. Eric, what are useful articles, and why did the Supreme Court take up Star Athletica versus Varsity Brands?
Well, briefly stated, pictorial, graphic, or sculptural works are protected under U.S. copyright law. Copyright also protects artistic features that have been incorporated into a useful article if those features are both separable and original. Now, for many years, there was a division among circuit courts regarding the appropriate test for determining whether the artistic features of a useful article were separable from the article itself. And here we have a list of the 9 tests that the office, scholars, and different circuit courts applied prior to the U.S. Supreme Court's decision in Star Athletica. As you can see, there were many different approaches and quite a bit of uncertainty prior to the court's decision. The question presented was whether the designs on these cheerleading uniforms were separable, and which test should be used to make that determination. Ultimately, the court found that the designs were separable and provided a 2-step test for evaluating separability.
When the Supreme Court established this 2-step test for separability, we needed to revisit our practices for useful articles. What is the 2-step test, and how will the office apply it?
So the test is summarized and discussed in Section 924.3 of the public draft. First, the office will examine the item for any features that can be perceived as a 2- or 3-dimensional work of art separate from the useful article. This is known as the separate identification requirement. Second, the office will determine if that feature would qualify as a protectable pictorial, graphic, or sculptural work, either on its own or fixed in some other tangible medium of expression, if it were imagined separately from the useful article into which it is incorporated. This is known as the independent existence requirement.
And how did we develop the proposed policies and procedures for useful articles in this draft?
So since the Supreme Court issued its decision, the office has applied the new test to many claims involving useful articles, including some cases where the applicant submitted a first and second request for reconsideration of the office's decision. The latest update to the compendium reflects the office's experience in examining these types of claims. We updated the examples of things that are considered useful articles, relying on the legislative history for the 1976 Copyright Act, the Star Athletica and Mazer v. Stein decisions, as well as earlier versions of the compendium.
Haven't we also clarified what type of items aren't useful articles?
We have indeed. The office provides guidance on things that are useful, but are not considered useful articles, such as X-rays, technical drawings, and other items that merely convey information. But please note, however, that just because these types of works are not considered useful articles, that does not necessarily mean that all such works are automatically copyrightable. The public draft clarifies that the separability test only applies to pictorial, graphic, and sculptural works. For example, architectural works, musical works, sound recordings are not considered useful articles under the copyright law and thus are not subject to the separability test, no matter how useful or functional they may be.
Are there other important takeaways you'd like to highlight here?
Yes, indeed. So the public draft of the compendium also provides guidance on several points. First, the fact that an artistic design makes the useful article more useful doesn't mean it can't be protected by copyright. A good example of this are the lamps at issue in the Mazer v. Stein case. The draft also includes photographs of one of these lamps so you can see it for yourself, and this is the image that is now included in the draft. The draft reiterates the Copyright Office's longstanding view, echoed by the legislative history of the copyright law and the U.S. Supreme Court, that copyright does not protect the overall shape of a useful article even if it is aesthetically pleasing. However, copyright may protect the shape of a particular feature of a useful article if it can be identified and separated from the useful article.
And will the new compendium section on useful articles be helpful to applicants while they are filling out their applications?
Well, we certainly hope so. The public draft offers practical guidance on how to submit these types of claims for registration. For example, the draft confirms that all of the artistic features of a useful article are considered one work, and generally, they can be registered on one application. If the exact same features appear on multiple useful articles, applicants may pick one representative item to submit for registration. So an example of this would be an artistic design that appears on a matching nightstand, dresser, and desk. If the exact same feature appears on all three items, you only need to submit images of one representative piece of furniture to register that design. Now, by contrast, if different artistic features appear on multiple useful articles, you would need to submit a separate application for each item. So in other words, if you have an armoire, night table, and desk that are sold as a set, and if there are different artistic features on each of those items, you would need to submit one application for the designs that appear on the armoire, another application for the designs on the night table, and another application for the designs on the desk. The draft provides guidance on how to assert a claim in the artistic features of a useful article, as well as the type of identifying material that should be included with the application. And finally, the draft explains that the office will add an annotation to the certificate to confirm that the examination revealed separable, copyrightable authorship in the work.
Great. Thank you, Eric. Moving along, let's talk about reducing correspondence and processing times. So why are we suggesting revisions that address correspondence with applicants?
Many of the updates in the draft address the office's practices for corresponding with the applicant during the examination of the work. Correspondence generally involves email communications between the examiner and the applicant. This may occur when there is missing, ambiguous, or conflicting information in the registration materials. Correspondence can be a lengthy process. This adds time to the examination of a claim, and it affects the overall pendency times for processing registrations. Under our current practices, approximately 25% of claims require correspondence. On average, this may add up to 3 months to the processing time for a web claim. If you submit a paper application, it may add up to 7 months to the processing time. Now, processing times are important to both the office and our applicants, and the office is actively seeking ways to reduce processing times to ensure that applicants receive a certificate of registration or a refusal within a reasonable time. So to that end, the office reviewed its practices to identify ways to reduce correspondence. We expect that these changes will positively affect processing times, but also reduce the number of cases that are closed for a failure to reply to correspondence from the office.
So I've just teed up sort of our next point. This is an example, variances, of a change that will affect our correspondence practice.
Right. So when an examiner discovers conflicting information in the registration materials, he or she may take different actions depending upon whether the variances are material or immaterial. Under our current practices, an examiner may disregard the variance, add a note to the online public record, annotate the claim, or communicate with the applicant. If there are numerous variances or deficiencies in the registration materials, the public draft explains that the examiner may return the claim to the applicant, require the applicant to correct and resubmit the claim, or the examiner may simply refuse registration.
And are there certain areas where we will no longer correspond with applicants?
Yes. So the draft clarifies that the office will no longer correspond in these situations. If the name of the claimant is omitted, the author's name will be added to the claimant space with an annotation. When the claimant's address is omitted, but is contained in the correspondent or mail certificate spaces, the examiner will add that address with an annotation. Now, if there is a substantial variance between the title given in the application and the deposit copy, the title given in the application will not be changed. When an applicant asserts a claim in material that does not appear in the deposit, the examiner may add an annotation identifying the error in the application. Another example, if the applicant asserts a claim in uncopyrightable material, but the deposit contains other copyrightable material, the examiner may add an annotation describing the copyrightable material that appears in the deposit.
And how are we changing our practices for uploaded deposits?
So when you upload a deposit copy to the electronic registration system, it has to be submitted in an acceptable file format. Otherwise, the office will not be able to open the file and examine the work. The office added a feature to the system that blocks unacceptable file formats. However, this feature cannot detect unacceptable files if they're submitted inside of a zip file or on a physical disk. The public draft of the compendium clarifies that the office will refuse registration if an applicant submits an unacceptable file on or after December 17, 2017, which is the date that these technical changes went into effect.
All right, and so final question on this. Are we changing how we handle claims submitted using the wrong application?
We are. Just a brief note about what the office will do when an applicant uses the wrong application form. In the past, examiners generally would communicate with the applicant if they submitted the wrong type of application, and they would instruct the applicant to resubmit the claim using the appropriate form. Under our current practices, the examiner may refuse registration in this situation. In particular, the public draft confirms that the office will refuse registration if the applicant files a single application where a standard application is required. Similarly, we may refuse registration if the applicant uses the standard application to submit a group of newspapers, newsletters, serials, photographs, or works that were first published as contributions to periodicals.
I'll just also note that this also applies to our new registration option for unpublished works, right?
Yes, which we will be discussing in just a minute.
Fantastic, thanks. All right, that brings us to rulemakings. Since the last compendium was released in 2017, the office has released a number of final rules updating our registration practices. We have updated the deposit requirements for many literary works and musical compositions. We've released group registrations for unpublished works, published and unpublished photographs, as well as newspapers, newsletters, and serials. We also streamlined our regulation regarding copyright notice. As a result, the compendium has been updated to reflect many of the rulemakings that we have conducted over these past 18 months. Eric, could you walk us through these changes?
Sure. So let's start with the first item on the slide, the deposit requirements for literary works and musical compositions. Early last year, the office issued a final rule establishing new deposit requirements for musical compositions and literary monographs. Monographs are defined in part as works published in one volume or a finite number of separate volumes. Here is the definition of literary monographs and its deposit requirements. Now, under the prior regulations, 2 copies of the best edition generally were needed to register these types of works and to comply with the mandatory deposit requirement. Now, under the new rule, copyright owners are able to satisfy both requirements by submitting 1 copy of the best edition. However, the office does reserve the right to demand a second copy under the mandatory deposit provision if the library should need it. Now, here we have a table that summarizes the deposit requirements for musical compositions published in the United States. If you look closely, you can see that 1 copy is required in all cases, and the format of the deposit depends on the manner in which the musical composition has been published. This table can also be found in the office's circular, Copyright Registration of Musical Compositions.
All right, so what changes did we make for group registration of photographs?
Also early last year, the office adopted a final rule modifying the procedure for registering groups of published photographs which is known as GRPPH, and we established a similar procedure for registering groups of unpublished photographs. This is known as GRUPH. Photographers seeking a group registration generally must submit their applications through the electronic registration system, and they can include up to 750 photographs in each claim. The unpublished collection option, which allowed an unlimited number of photos to be registered with one application, and the pilot program, which allowed an unlimited number of published photos to be registered with the same application, have both been eliminated. However, the pilot program for photographic databases does remain in effect for the time being. Some additional features of the final rule. It clarified the deposit requirements for GRPPH, GRUPH, and photographic databases by requiring applicants to submit a digital copy of each photograph and a separate document containing a list of the titles and file names for each photo. The rule also confirmed that a group registration issued under GRPPH or GRUPH covers each photograph in the group, which means that each photograph is registered as a separate work. The group as a whole, however, is not considered a compilation or a collective work. Finally, the rule clarified the eligibility requirements for this option, namely that all the photos must be created by the same author and owned by the same claimant or organization.
All right. And so how about group registration of newspapers?
This final rule was adopted effective March 2018, and among other things, publishers are now required to file an online application rather than a paper application. They're also required to upload a complete digital copy of each issue through the electronic registration system instead of submitting them in physical form. Additionally, each newspaper issue in the group must be a new collective work and a work made for hire, and the author and copyright claimant for each issue must be the same person or organization. The new regulation also clarifies the scope of protection for newspaper issues by confirming that a group registration covers each issue in the group. And the public draft for the compendium further clarifies that the articles, photographs, illustrations, or other contributions appearing within each issue are also covered by the registration if they are fully owned by the copyright claimant and if they were first published in those issues. Now, a quick note, the office recently eliminated the previous requirement that said that applicants had to submit a full month of new issues within 3 months of publication of the earliest issue in the group. That requirement was eliminated in January of this year.
All right, so we also have group registration options for newsletters and serials. Were those updated as well?
Yes, we updated or issued a final rule for newspapers, or newsletters and serials rather, in November of 2018. As with newspapers, newsletter publishers are now required to file an online application rather than a paper application and upload a complete digital copy of each issue through the electronic system instead of submitting them in physical form. Publishers of serials are encouraged to register online, but the office will accept paper applications and physical deposits until December 30th of this year, 2019. For newsletters, the final rule eliminates 2 prior requirements. First, that each issue had to be a work made for hire, and second, that claims had to be received within 3 months after publication. Both of those requirements are now eliminated. For serials, the final rule clarifies the following requirements. Each application must include at least 2 issues. The serial generally must be published at intervals of 1 week or longer. The publication dates given on the application do not necessarily need to match the dates appearing on the issues themselves. And the rule confirms that each issue must be an all-new collective work. Finally, the rule on serials and newsletters separates mandatory deposit from registration. So what does that mean exactly? Well, previously, applicants had to provide the Library of Congress with 2 complimentary subscriptions in order to use these group registration options. Now, Group serials and newsletter applicants only need to upload the copies being registered. Now, they may also need to separately submit 2 complimentary subscriptions directly to the library if their publication has been selected for the collections. But again, that is no longer a condition of seeking a group registration.
All right, so that brings us to our most recent group registration update, group registration of unpublished works. Can you tell us more about this option?
Sure. The office adopted a final rule effective March 15th, 2019. The new option for unpublished works replaces the prior option for unpublished collections. The new procedure allows for a much more detailed public record. Each work will be individually listed on the application, and each work will be considered separately during the examination. Since March 15th, applicants are required to use the online application specifically designed for a group of unpublished works, and they must submit electronic deposits. The standard application may no longer be used to register multiple unpublished works. As a general rule, applicants may include up to 10 works in each submission. Now, there is a limited exception for claims involving sound recordings. When registering a sound recording, together with the work that is embodied in that recording, applicants may submit up to 10 sound recordings plus the 10 recorded works embodied in each recording, provided that the author and claimant for all of these works is the same person or organization. In all cases, the author of the works must be named as the copyright claimant, and all of the works must fit within the same administrative category.
Okay, so just to close the loop and cover all of our rulemakings, what about copyright notice? Did we make substantive policy changes to our notice regulations?
Well, not exactly. The compendium has been updated to incorporate a non-substantive technical change to the regulations that govern the requirements for using a copyright notice on various types of works. So essentially, the compendium has been updated to reflect these citation changes.
All right, citation updates, always fun. So let's move to our final topic, publication and making available. So in 2016, the Copyright Office released its study on the making available right in the United States. What is the making available right, and what did the Copyright Office focus on?
Good question. So in 1996, member states of the World Intellectual Property Organization implemented what is known as the WIPO Internet Treaties. Among other provisions, the treaties affirmed the operation of the author's exclusive rights in the online environment. This included the author's ability to authorize, quote, the making available to the public of works in such a way that members of the public may access those works from a time and a place individually chosen by them, end quote. In a recent study, the Copyright Office focused on how the exclusive rights of distribution, public performance, and public display collectively meet and adequately provide the substance of the making available right.
And so how does that bear on the compendium?
Well, the compendium devotes an entire chapter to the topic of publication. That's chapter 1900. And it clarifies that publication may involve one of 2 actions. First, the distribution of copies or phonorecords to the public by sale or other transfer of ownership, or by rental, lease, or lending. Second, publication may also occur by offering to distribute copies or phonorecords to a group of persons for purposes of further distribution, public performance, or public display. Now, in the Making Available study, the office concluded that distribution is properly construed to cover that making available of copies of works to the public, regardless of whether the copyright owner provides proof of acceptance of a copy by the end user. The proposed compendium draft incorporates this principle. Offering a work directly to the public constitutes publication, where the offeror has completed all steps necessary for distribution to the public. Conversely, where there is an offer, but additional action by the offeror is needed in order to initiate distribution, publication has not occurred.
Okay, so is there a way that we can wrap our heads around this?
Well, the compendium draft includes two examples. The first example involves an online advertisement that offers to sell an e-book to the public, but does not make the e-book available for download. In this example, that does not constitute publication of the e-book. A second example, an offer by the copyright owner on a public website to purchase and download an app that they developed and made accessible on that website. In this example, that constitutes publication of the app.
Okay, thanks, Eric, for all this information. We've covered a lot of updates made in this round. Can we review one more time how people can submit their thoughts and suggestions in response to proposed changes?
So as we mentioned earlier, this update has been released in draft form to give the public an opportunity to review and provide comments on the revisions. To be considered, comments must be received by May 14th, 2019. Specific instructions for submitting comments are available on our website. Now, if you don't have access to a computer or the internet, please contact the office by email using the Contact Us link on the Copyright Office website. Or you can reach us by telephone at 202-707-3000 or toll free at 1-877-476-0778.
All right, thank you, Eric. So now we are going to turn to our question and answers. Give us about 30 seconds as we take a look at what's been submitted so far, and we will get started. Thank you. All right, thank you so much for holding. So just to get started, we've had some technical questions about whether or not the slides or the webinar will be made publicly available, and the answer to that is yes. We will be posting the webinar as it's been recorded, so we're actively recording right now, and we'll post that to the Copyright Office's YouTube channel. There's a little bit of a turnaround time on that, but I believe that we have the ability to send a notice to participants that the webinar is available for viewing. Okay, so our first question from the audience is about variances. And the question is, Eric, how is a material variance defined?
Right, so this goes to what we were talking about earlier about our new practices for reducing correspondence and hopefully reducing pendency times. We talked about how the office has different practices for dealing with a variance, which is basically where there's something amiss or something wrong or something unclear with the application as compared with the application versus what's in the deposit. And we do have fairly detailed practices that vary depending upon whether the variance is material or immaterial. So the question that we got from the webinar is, well, how do you know if a variance is material or immaterial? I would direct your attention to section 603.2 of Compendium, which talks about this issue directly. I don't believe off the top of my head that this is a section this specific section that's been revised, so this language I believe is in the current version already. But I'll just read the section here. It says that a variance is that substantially affects the required information that should be included in the application or any of the essential issues that should be resolved before the registration can be made, I think is what is the gist of it there. A material variance is a variance that substantially affects the required information that should be included in the application or any of the essential issues that should be resolved before the office may complete a registration. And again, that language comes from Compendium 603.2, which of course is in Chapter 600.
Okay, great. Thank you, Eric. The second question that we have is about group registration availability. The question is, do manuals fall under the group registration options? For example, construction standard specification manuals that are updated every year.
So it's an interesting question. The office has the authority to create group registration options for a group of related works. That's language that comes to us directly from the statute. And so all of the group registration options that we've created have some sort of relationship among the works. And typically they all fall within the same either administrative class or the same general types of works. So for instance, we have the option for newspapers. That's only for newspapers. We have an option for newsletters. That's only for newsletters. We have an option for photographs, only for photographs. With respect to manuals, whether it could fit or qualify for any particular option would depend on whether it fits within the general class of things that are eligible to be registered as a group. One thing we can say for certain is that if the manuals are unpublished, then in all likelihood they would qualify for the new group registration option for unpublished works. That may not be a viable option. If they are published, obviously, it would not be an option. And if they're published or created every year, it may not be feasible to wait to have and register, once every 2 years or every 3 years. It may not make economic sense to wait that long just to group them together for purposes of submitting them to the office. One thing to consider is whether the manual would qualify as a serial. It's hard to say from the question. I would read to you, though, from the regulatory definition of what a serial is, which says that a serial is a work issued or intended to be issued in successive parts bearing numerical or chronological designations and intended to be continued indefinitely. This class includes periodicals, including newspapers, annuals, and the journals, proceedings, transactions, etc. of societies. That's language from the regulations. It's in 202.3 of our regs. And again, that's the definition of what a serial is. Similar language for that regulatory definition also appears in Chapter 1100, Section 1107, which is the section that deals with group registration of serials.
Thank you, Eric. We're going to take one more pause. We've got another batch of questions. We're just going to take a read down, and we'll be with you in 1 moment. All right, thank you for allowing us another breather. We have 2 more questions. So first, do you have any updates on whether the interim secure test registration rules will be finalized and included in the compendium?
Okay, good question. So for those of you who don't know what Whitney's talking about, the office recently issued 2 interim rules which updated our procedures for registering secure tests and also created a new group registration option for registering specific questions that are used in a secure test. So what's a secure test? It's everything that most people had to go through at some point in their life. A test that you go to a test center, you sit down with all of your colleagues, or perhaps you sit down by yourself. You take the test, and you're being closely monitored by a proctor. The office has very specific and very detailed procedures in place to register these types of works, and those procedures are designed to protect the confidentiality and security of the test. So in essence, that by registering your work, you're not giving up that which makes it valuable, which is the fact that it's secure. So the office has registered secure tests dating back to 1978. We recently issued the 2 interim rules that I mentioned that updated our regulations to bring some consistency and to improvements to that procedure. The interim rule is in effect, and applicants can and do make use of that procedure. At this time, we've not added any specific instructions to the compendium on how to go about using the procedure. And the reason for that being that the interim rule is still under consideration and it's not final yet. We did receive a number of comments on the interim rule. We are carefully considering those comments, and we do expect to issue a final rule at some time. I'm not entirely sure when that will happen. But when it does happen, we will be updating the compendium to include information on this procedure. In the meantime, the best resource for learning more about the procedure, what's required of you, what's expected of us, is by looking at Circular 64, which is, of course, aptly named Secure Tests. And you can find that on our website.
Great, and I will just put in a plug. When we do release that final rule, we publish that in the Federal Register, of course, and then we also have an announcement through our Newsnet system. So if there's anyone on this call who's not signed up for our Newsnet service, I would highly encourage it because that is a great way to know exactly what we are up to from the moment that we announce it publicly.
And I will just acknowledge that we do have placeholders in the draft compendium where the information on secure tests will be provided once it's ready to go.
All right. So next question, and here it is. Will the new guidance on group registration of short online literary works be available?
Right. So another great question. And again, for those of you on the line who don't know what Whitney's talking about, last December, the office issued a proposal to create a new group registration option, which would be for short online literary works. This would be an option designed for things like blogs, Facebook posts, short articles, short stories, basically textual works that are published online. There are various requirements that we proposed in the proposed rule, among which is a word count limit. The works, in order to be considered a short online literary work, the work would have to contain at least 100 words, but no more than 17,500 words. The works would have to be created by the same individual author, and they would have to be published online within a certain time period. That proposal, again, was published in the Federal Register in late December. We've received comments on the draft, which we are carefully reading. And as with secure tests, once we reviewed the comments and issued a final rule, the compendium will be updated to include additional detailed information about how this option will work. In addition, I expect that we will also have a circular devoted to the same topic.
All right. So, hearing no more questions, just wrap things up for today. Here's some more place to find more information, because today's webinar is meant to highlight our proposed compendium, but the Copyright Office has a host of materials and support for your ongoing copyright and registration needs. On our website, you can access our regulations and both the current and proposed draft of the compendium, as well as informational circulars on a range of copyright topics. Our Public Information Office, PIO, is available to answer specific questions by phone or by email. I want to thank Eric, our staff, Erin, Jalise, and Annette supporting the webinar, and each of you for your time today. Thank you so much for listening in and for asking some great questions. I encourage you to reach out with follow-up questions for the office. I'll put another plug. If you would like to keep abreast of Copyright Office activities, please sign up for our Newsnet service by visiting copyright.gov and clicking News at the top of our page. Thank you so much and have a great day.